I think.
All right, we are back in Senate Judiciary. It's the 31st. We have Senator Chittenden here to introduce S11. And the floor is yours.
Thank you. I want to thank you all for your time and just say from the outset, this bill costs nothing and other states do it. So hopefully that it piques your interest. And, I'll defer to Ledge Counsel to confirm this statement, but I understand it is modeled after Oregon's law. So if anything, that's one of the states that has this that inspires a lot of the approach. And that has to do with how our constitutions are written. But I do have written testimony on the website, but I thought for those at home watching this on YouTube at double time speed, I would just go ahead and read through some of it just to give it some context. When a business is sold, its future is uncertain. Will the new owners maintain the same commitment to local jobs, environmental practices, and community support? Patagonia founder Yvon Chouinard refused to leave that to chance. So he established a stewardship trust. He ensured his company's values would remain intact. This bill brings that same powerful option to Vermont. It allows businesses to protect their legacies and honor their commitments they make, enshrining their values in the governing documents of the business beyond the reach of changing boardroom priorities. What is the problem we're trying to solve with this bill? Succession crisis. 2/3 of businesses nationwide are owned by baby boomers. And just yesterday in a presentation in economic development, they showed how disproportionately Vermont has an even larger percentage of baby boomers who own a lot of our small businesses. We're the third oldest state and we're particularly vulnerable. Many owners struggle to find buyers who share their commitment to the community. There's also a loss of local values. All too often, businesses are sold to large conglomerates or private equity firms prioritizing profit maximization over local jobs, environmental stewardship, and community support. The case of the Vermont teddy bear serves as a stark reminder of these potential losses. Limitations of existing solutions. Even employee stock ownership plans, ESOPs, while well-intentioned, face significant challenges. Their complex regulatory structure under RISA mandates maximizing value for retirees, potentially leading to unwanted acquisitions. Furthermore, the high cost of establishing an ESOP can create a significant barrier for many businesses. The solution that this bill, I was always told by Tim Ash when I started this gig 4 years ago, he said, you always want to define the problem and how the bill solves it. So the solution that the stewardship trust bill offers offers an option for businesses to create constitutions. This bill would give Vermont businesses the option to adopt a stewardship trust, a model akin to establishing a constitution for a company. Just as the Constitution protects the principles of the democracy from the whims of individual leaders, a stewardship trust safeguards a company's mission and values through generations. It preserves mission and values. These trusts would allow, if they were so chosen, would allow business owners to codify their commitment to local hiring, ethical supply chains, environmental practices, and community support, ensuring those values endure beyond their ownership. It also would allow for protecting against unwanted takeovers. Unlike ESOP, stewardship trusts are not subject to the same pressures to maximize short-term financial returns, preventing unwanted acquisitions that could harm Vermont communities. This also would facilitate employee ownerships. This legislation also enables the creation of employee ownership trusts, a type of stewardship trust specifically designed for employee ownership. DOTs offer a more accessible and affordable alternative to ESOPs, empowering employees and strengthening the Vermont workforce. Patagonia example. The success of stewardship trusts, as I previously mentioned, is exemplified by Patagonia. They use the structure to bake in their company's unwavering commitment to environmental sustainability that would continue regardless of future ownership. So this model would allow Vermont businesses to similarly safeguard those core values. The advantage to Vermont is currently Vermont businesses must rely on out-of-state trustees for these trusts. I don't know if there's a lot of pent-up demand for this, but if Burton wanted to inform a stewardship trust beyond a B Corp certification, which is a certification that can come and go, this would be an option for them to keep that stewardship trust within the state of Vermont rather than to go beyond our borders. This bill empowers Vermont institutions such as the Vermont Community Foundation to serve as trustees, streamlining the process and keeping this expertise within our state. There are economic and community benefits. This could preserve jobs by facilitating business succession within Vermont. This bill also helps retain local jobs and strengthens our economy. Well, it could strengthen our economy. It also offers the opportunity for protection of environmental stewardship to ensure that businesses committed to sustainable practices can continue their vital work beyond the current order of priorities. It also could allow for strengthening of communities by preserving local businesses and their community support programs while protecting the social fabric of Vermont. This legislation presents a unique opportunity to protect Vermont's business communities and values. By embracing stewardship trust, we can empower business owners to create a lasting legacy while ensuring a vibrant and prosperous future for our state. Our legislative counsel, Eric Fitzpatrick, will offer that this is based, I hope, on Oregon and how they have allowed for stewardship trust. Important to offer is that this bill is inspired by the very diligent work of one of the brightest recent graduates from the University of Vermont Grossman School of Business, Sustainable Innovation, Masters in Business Administration program, named Nora Devlin, who I hope is watching YouTube right now. She would be an excellent witness to hear from if the committee had time to consider further testimony. Additionally, Mark Lankin, attorney at Dents here in Vermont, was also involved and consulted with on the drafting of this stewardship trust, and I believe he referred or encouraged, and I'll leave this to Eric, to elaborate on, but Robert H. Sitkoff, professor at Harvard Law, also might have some thoughts on this bill as well that you might want to entertain if you have time to do so. That's my spiel.
Thank you. And with preemptively apologize regarding scheduling. I'm still getting the hang of figuring out a good amount of fair amount of time for folks to introduce and walk through bills. So I'll hold any questions I have so we can hear from Eric and just take it from there.
Thank you. I'm going to get back to the committee.
Sounds good.
Cheers.
Thank you.
Thank you all.
Hi. Did you want to provide us a general overview?
Sure,
Walk through of the bill?
yeah, whatever time you have, I can do a little bit now or wait, whatever works for you.
That's it.
Yeah,
And
yeah,
then
sure.
if there's interest among the committee, we can revisit and take a deeper walk through the future.
Morning, everybody. Eric Fitzpatrick with the Office of Legislative Counsel, as the chair indicated, to provide a bit of an overview on S11, Senate Bill 11, and Act relating to stewardship trust. Have you heard, as you heard from Senator Chittenden, this is based on some language that has been passed in Oregon, in particular, having to deal at the request out there of the principals in the Patagonia organization, an attempt to create an entity like this that would provide for the continuation of the principles of the business to maintain the whatever the operating principles of the business, that sort of thing. The idea and the reason that I think it's important to know is, well, why could this be done now? Like, what's the approach taken in statute to address the reason that someone says better want to be now? It's actually pretty straightforward. If you look at the language, that what this does is it allows on line 13, page 2. It says a stewardship trust can be created under this section for a business purpose without a definite or definitely ascertainable beneficiary. The reason for that, and the reason that this is necessary, is because generally speaking, a trust, in order to be valid, has to have an ascertainable beneficiary. Has to be a beneficiary, someone who benefits from the property in the trust. You know, the trustee manages the property and they make distributions to the beneficiary. The beneficiary is the person who has legal standing to go into court and enforce the terms of the trust. So there has to be a beneficiary, because otherwise there's nobody who can enforce the trust. Beneficiary is the person who can. So that's generally true. There's an exception to that. And the exception is a charitable trust. A charitable trust does not have to have an ascertainable beneficiary, because the statute for charitable trust specifically provides that the person who can enforce it is the Attorney General. Charitable trust can be enforced by the AG. So there's somebody who can enforce it, right? Generally speaking, with trust, it's the beneficiary who enforces it, except for charitable ones where the AG does. So this, you see, creates another exception. This says, because this specifically says, hey, here's another case where you can create a trust without an ascertainable beneficiary. And this stewardship trust is that entity. So it gives another way, because without that statutory language, without the creation of this entity, a business couldn't do this. Has to have this express statutory authority to do it, because otherwise it wouldn't be a valid trust, because there's no beneficiary, no ascertainable beneficiary. And so sort of in place of that, what this structure does is it creates, you'll see over on the middle of page 3, creates a trust stewardship committee, that subsection D. So you have this group of people who are elected, who work with the trustee to make sure that the the purposes of the trust are complied with. There's specific language about how this trust stewardship committee is selected, how people get appointed to that committee or chosen for the committee, if there's a vacancy. So that's a lot of sort of managerial language there. But the idea that this trust stewardship committee had the ability to make sure that the terms of the trust are complied with, you sort of think about it, in some ways that's similar to what a beneficiary might do. But this doesn't have an ascertainable beneficiary, that sort of body instead. And it allows, as Senator Chittenden was indicating, it allows a business, for example, to use a business entity like this or a structure like this to have a trust committee that makes sure that in the future, the business is operated in a way consistent with whatever principles the original business wanted to have. But it statutorily has to be express or explicit, or it wouldn't be a valid trust. One last thing I'll note, I don't want to pretend to be an expert on this, and this will be, if you hear from the Harvard professor that Senator Chittenden mentioned, there's an interesting legal issue that make a recall actually having to do with the rule against perpetuities.
I was worried I was going to hear those words.
Yeah, I know, no one wants to say it. It's hard enough to explain. But I don't want to try and do that right now. The general principle of the rule against perpetuities is that property interests and interests are not supposed to last forever.
Right.
And we have a specific provision in the Vermont Constitution that prohibits property interest from lasting forever, as well as
500 years is kind of seems like forever, more or less. Compared to 21 years in the rule against.
cost of life, right? But yeah, exactly. So you're right that's sort of an attempt to thread the needle, and that's on the bottom of page 1. You see, this isn't forever. It says, trust may not be enforced, or it extends to 21 years to 500 years. So in other words, it permits it to last for a lot longer.
Yeah.
Not forever, but a lot longer than 21.
Yeah.
So is that 500? There are a couple other states that have used 500, but some other states have used a lower number. The whole idea here is to comply with this constitutional and common law principle that property interests can't last forever. You just have to be aware that it's conceivable that someone might challenge it and say, well, 500 is still looks a lot like forever. Yeah. Or somebody else might say, it's a very new, there's only a couple of states that have it. So it's a new thing. It's not like there's any case law out there that I'm aware of. It says 500 is more like not permanent or more like forever. But you got a good start.
We can mull on it for a bit, but we're gonna head to the floor and sorry for having to rush you through.
No, not at all.
Walk through, but
No.
yeah, thank you.
Yeah, sure thing.